on whether your participation has been infringed. And we know that it has. There are two things, how and whether are worlds apart in this connection. Then there's the issue of the narrowing. I don't even have to spend time there because we've gone through this. Well, all we are saying is that the mere fact that the category of offenders called those who buy conferences is now excluded from the so-called categories is itself a narrowing or an amendment, whatever you call it. And that the NEC does not have that jurisdiction. Again, it's ultra-virus. The NEC has no jurisdiction to narrow, amend, vary, whatever you call it, a national conference resolution. Simple. That's just how the ANC works, I'm afraid. So if that is so, then the amendment is by itself unlawful. Forget the morality of whether it's done for factional purposes or whatever. Just at a technical level, it's not allowed to be done. And by the way, another interesting, if there's a fourth dimension contradiction to the issue that this is not a disciplinary issue. If you go to the guidelines, I think it's paragraph 3.3. It says that of the guidelines, it says that a person will be suspended pending disciplinary measures, which goes back to the debate that we had. So even the ANC doesn't say what the court says, which is that this is a precautionary suspension. It sees that, or at least let me put it this way, the ANC recognizes that a real precautionary suspension is the one pending a disciplinary action, which this is not. I'll just try and get 3.3 of the guidelines. But anyway, I don't want to go back to that. Then the last point under the merits is what we call the unsolicited validation of the, or invalidation rather, of the Ramaphosa suspension. This court either, with the greatest respect, maybe it's our fault, maybe we didn't explain the nature of the relief we sought in 2.4. In 2.4, we were specifically, and I was at pains to point this out, we were not saying that this court must find that the suspension of Mr. Ramaphosa is valid or invalid. We were simply saying the principle is that that suspension cannot be invalidated by Mr. Ramaphosa himself at a press conference. It must be invalidated either by a court or any of the ANC's disciplinary structures or whatever. And you can't just wake up and say, it's like somebody gets fired at work and they don't give you a hearing, they don't do anything, they just say you must leave right now. You can't say, no, I'm coming to work tomorrow because this is clearly so unlawful. No, it doesn't work like that. You go to court or to the CCMA or whatever, and then you show that suspension was, or rather that expulsion or dismissal was wrong. That's how it works. You don't just wake up and say, look at it, look at them driving me out of the gate without a hearing. Then, therefore, I'm just going to rock up and invalidate it myself. It doesn't work like that. But the court not only did it not do that which it was supposed to do, it went to another area of saying, no, that suspension was invalid. Nobody asked it to do so. There's no counter application by anyone to say that it should be so done. And the court on its own just goes on and says, no, it was fine. And what is worse, the court then says what is also fine is the fact that Mr. Magashule, in his absence, having been unlawfully evicted, was found guilty and sentenced to an apology. And the court says it's axiomatic that if the Ramaphosa suspension was invalid, Therefore, you can be bundled out and be sentenced in absentia and be told that you have breached the rules and you must apologize and be sentenced to an apology in your absence. What has that got to do with whether the Mr. Ramaphosa's suspension was valid or not? Let's assume it was invalid. Can that then justify somebody being somebody who actually attended the meeting? You could have even said, okay, before we chase you out, there's this small matter of your letter. What have you got to say? No, you start by chasing them out. Then when they are gone, you say, we've found you guilty. We have not only have we convicted you, we've also sentenced you. And the court says that's fine, axiomatically. Well, yes. Yes, the point I wanted to refer to, I'm sorry, to jump back, it's 001-86 of the, where I want to refer to the guidelines. It says, conduct leading to a member office bearer being inducted to appear before a court of law, that is like Mr. Magashule, especially that of corruption, or any other serious offence could also constitute act of misconduct in terms of 2517 on the ANC Constitution, for which disciplinary proceedings could be invoked and instituted against such a member, office bearer, or public representative. So that's a cross-reference to 25.17.4 and 25.68. I'm doing this from memory, which are the rules that allow for temporary suspension on these grounds as well. So that's on any one of those 5 grounds, the reasonable prospects, particularly the stare decisis and the contradiction on the issue of punitive or pending disciplinary processes and so on. So then now we come to the issue of judicial bias. We have said that this court was biased or perceived to be biased, and because of some of the issues that I've raised and just a reading of the judgment, it would seem that the court, by any means, including condonation and strikeout application, duplications which are condoned, was just determined to find in favor of Mr. Ramaphosa and other respondents, no matter what.
Sorry, Mr. Mpofu, could I just understand the argument?
Yes.
Is the argument based on the totality and the consistency with which the court found against Mr. Magashule, taken collectively, sustains a conclusion of bias or a perception of bias? Is that the tenor of the argument?
No, that it is part of the tenor of the argument, but it's not everything. And that's and you are right, Justice Kolapen. That is the first proposition I was making. I was making about the overall one. That's why I'm talking about condonation, strikeout applications, like everything just had to be found against Mr. Magashule, even when it was blatantly. I mean, a small thing like not asking for condonation. A court should just, quite frankly, reprimand, even if it's going to find in their favor, any party that treats a court in such a blasé fashion and not even raise the matter, even in its heads of argument. But no, and as I say, a court cannot condone I've never seen it in my life, to be honest, where a full judgment is attached into an affidavit. I've never seen it, literally. Maybe it's me. So to condone things like that was just to say that there's nothing. Even if Mr. Magashule were to say today is Wednesday, the court would have found that no, he is wrong. What day is it? Tuesday, whatever. So
then he would have been wrong.
Yes, in that case, the court would have, yeah. But if he said it was Tuesday, the court would have said it's wrong again. So that's the point I'm making here. So
okay.
No, you go, Judge Kolapen.
Karen Cherise.
these issues, the court found that in regard to the condemnation, there were 2 or 3 days unexplained by where the president was late and he asked for condemnation. The other explanation by the
second and third
was that they believed that there was an agreement. This was never raised at the case management, and we found that because it was never raised at the case management, because there was no response to the letters, that they were in right to do what they did. So let's put that aside. Then, just one sec, I'll come back. Then in regard to striking out, we asked the question about what the prejudice was, because there's got to be a purpose to the striking out. It's got to contain something which shouldn't be there for material reasons, not just because it happens to be a duplication or a something that's added in that could have been in a different place. What would it have helped you, other than on the question of costs, if we would have struck out certain of the documents which you requested the court to do? How would that have changed the course of the matter?
No. Strike out, I'm afraid, is not about changing the course of the matter. Strike out, the purpose of Rule 615 is about getting rid of irrelevant matter. It's got nothing to do with changing the course of the matter. So if you can say to me, how would it have helped me if the public protector's report was not put there, or if the judgment of the High Court was not put there? Well, it's not about helping me. It's about, as I said, even helping the appeal courts. The appeal courts are now going to have to go through the same reams of irrelevant documents. Surely, Justice Wayne, there's no court that can condone such a thing, really. The purpose of Rule 615 is exactly to weed out that kind of thing, to introduce discipline, if you like.
We'll take you back there momentarily.